the same idea, you can file it in India, and within a year then you file it in different countries, either through the Paris Convention or PCT, and you can take it in multiple countries. So that's a very interesting aspect, or that's a very important aspect. And this is, you're not alone when you face those issues. There are provisions in the patent law where they protect you, and they are designed for exactly these. In fact, a lot of companies keep tracking. They delay as late as possible and file as many applications as possible related to that single idea. And they keep track of competitors. वो क्या कर रहे हैं? They write applications designed because they've got a date, priority date. They write applications which are designed to capture a market or capture a product line which is as large as that. And patents in the modern world are actually meant as currencies to be traded, to be traded against innovation. So your idea and my idea, we cross-license and then take it from.
So that's one thing more on the design aspect, like a mobile is there, right? So if a person files a patent on this mobile design, so more or less the mobiles look the same, with small changes here and there.
Right.
Then how does a patent help in the design thing? Like if I make a small change in the thickness or the length or breadth, will the patent still be there, or what happens?
I think these are the issues that Apple and Samsung are fighting on, but there are a lot of patent issues which are going on with major mobile companies. But you're right that the patent can't be very broad. So the patent is usually restrictive. If you can make suitable changes, the patent that someone else could have a similar product. I don't think there's something you can do to stop that. I don't know if you have a different.
So there's a patent for there's a design, and then there's a patent, right? One is covering a utility. That's the pure play patent. Then there is a design. Design is you covering the broad contours of the like the way the Coca-Cola bottle looks. That's design. But the under ki technology, for example, very interestingly, Apple sued Samsung. Apple sued Samsung for a patent on slide to unlock. Slide to unlock.
Okay.
Now you can't get a design for that. That's a pure play. They said technology. Yeah, वो bounce होता है. You get the screen down and it bounces. So they sued them on bounce. So these are pure play. Improvements or implementation of technology on inside the system. It's not a design per se. So for a manufacturing angle, one of the very important aspects is also to look at designs, which is a design right, which is a little separate from patent, but it's governed by the same act or the similar acts. So I think your queries need a little bit more counseling. आपको कोई X-ray और ECG और उन चीज़ों की ज़रूरत है. These are not OPD questions.
Can one provisional application be converted into arrays of?
100%. That's exactly what.
Because I have filed a provisional in December.
Yeah.
But as we have now made the product.
Yeah.
So now, but we are seeing that to safeguard everything, we might need 2 or 3 patents because there are 2-3 different technologies that have to be saved in that.
That's exactly what I was saying.
So I was just thinking because I had hired a person, but he was not doing work, so I had to buy my own class 3 certificate. And in 1600 I did the whole work myself. So and I made a broader system.
Yeah.
And now it has to be, because I have not done the claims, so now I have to do the claims and then we are specifying the things. So I was just thinking because right now in the process it was coming that I might have to go for 2 patents. So then I was thinking on the dates, which date would be taken. So now could I say to the patent office that this is the provision? So now these are the 2 applications that is coming out of that.
Yeah. You should take a business card from Vanessa.
Okay.
Talk to her.
I think that we maybe specific queries we can take later on, or we can discuss offline.
But the point is that that's exactly what I was talking about. That during the year you'll come up with many new ideas and innovations that on their own will be able to qualify as different ideas, and that's where the real value of your intellectual property will lie. When you go to an investor with that product, they'll also ask you, do you have a patent for that? And then you say, okay, I have multiple patents on this, and this. So it's usually the basic technology versus what you have improved over the technology, incremental innovation that you look at. One more very important point that we wanted to talk about was trademarks. So at a startup stage, when you're naming your company or naming your products, it's very important to have a sound trademark. So do you have any thoughts on that, Vanessa?
Yeah, I think that when you start the company and you have to think of a name which is going to be with you for a long time, one should find out if there is some trademark which is already taken by somebody else for that name. And you can also have your name with different fonts, colors, and find out if that helps to change whether it can be trademarked or not. And when you have a logo, you should also see whether it is a distinct logo. You can check the domain name, whether that is available. So these kind of background work should be done before thinking of any name, because the name becomes very important. I think that very general terms cannot be trademarked, so you have to be careful that you don't pick a very common name, which is, like you can't pick a pen or something. You have to pick something which is distinctive, or you have to make the trademark or your name distinctive by adding some style, some font, some color to that. So in the beginning, it's good to do a trademark search. I think it's very easy to do it now online. So even without having any legal advice, you should be able to do a trademark search to come to a name which is distinct and which you can trademark in the future, if not right away.
Yeah, I'll come to you. So as you said, you can go online and do a search. So you had a question?
So a trademark, does it have to be on the registered entity's name, or can it also be on the, let's say, brand name that we come up with? So just want to understand the difference between that two.
So it can be either. You can have a trademark for the registered name of the company that you have, and you can have a different trademark also. So many companies have different lines of products that they have trademarks for all of them. You can have either, or you can have both.
Yeah. And trademark is it's something which has become very litigious right now. So you've got to be very careful in choosing your name. I've seen many companies being sued or getting notices because they are stepping on somebody's name by remote. So even if it is deceptively similar to another name, that's what the trademark law says. Then somebody can and deceptively similar is something for you to decide. You as a trademark holder. And coming to your question again, as Vanessa rightly pointed out, you can be on any company, it can be any brand name, and very importantly, between the company name and the trademark wins. I've seen कि लोगों की कोई trademark infringe करने वाली company है, उन्होंने वही trademark ले लिया, उन्होंने कहा हमारे को तो ROC ने trademark का नाम दिया है, हमें तो we have been given this name by the registrar of companies. The Trademark Act itself says between the trademark and the company, the trademark wins.
And a follow-up question on that. So a company let's say I have a company in India with the name of Azura Tech. Can a company in South Africa with a similar name sue me on, or do I hold any liability for any different country's registered trademark name? Is that something that do I hold any liability towards it?
No, if you have a trademark in India and they have a similar trademark.
I don't have a trademark in India, I just have the name with which I started off my business. There is a business in South Africa which is trademarked the name over there. Am I liable for anything for that?
You're not liable for anything. When you apply for a trademark in India, it's possible they may also apply for a trademark in India, or they may object to your trademark. But there is nothing stopping you from getting a trademark in India unless they have also gotten a trademark here, or they've gotten a worldwide trademark.
Yeah. Are you in the same line of business?
Sorry? Yes,
Are you in the same line?
they're into hardware and I'm into software. So,
Okay.
not really.
And so these are some of the questions that need to be, and then there's the same name. And are they selling in India?
No, they're not.
And you are selling in South Africa?
Yes.
Right. So again, intellectual property right by its very nature is very market based, very country oriented. It's very international. However, the domestic right is very country oriented. Right. So what country are you fighting each other? Which country are you taking up each other? are you taking it on, are taking them on in South Africa, they are taking you on in India, or you're fighting in a neutral country? So who got there first? Who filed the trademark first? Did you oppose the other person's trademark? Did they oppose your trademark? So these are some questions that need to be answered. That's the case law that comes.
And also, if you have, even if they don't have a trademark, if it's a well-established trademark, they can say that you're passing off your product as if it was their product.
Yeah.
So if there is some proof of that, then you could be in trouble under general law, not just trademark law.
And can I get a trademark in my name, or it has to be in the company name?
No, that's what he asked, you can get it.
No, ma'am. My point is, it's not a rift between two different companies.
Mhm.
If I apply for a trademark in my name, so that if I join one company, if I have
Okay.
a few partners, if I move out from there, so the trademark goes with me. Is that kind of thing possible?
Yeah, that's what you do. Yeah.
So I can take a trademark in my personal name.
Unless the company you're working for doesn't have any issue with that under your employment contract, there is no issue under law.
Okay.
I think
If it's
that's-
your company, you take it in your name and then you assign the trade name to them and take a licensing fee and get some money, personal. That's how people work, right? Trademark, like intellectual property globally is a very, it's actually like trading currency, right? You sometimes you develop develop a technology yourself in your backyard, license it to your own company. GST issues apart, but you license it to your own company and then get a licensing fee back, or you license it to your own subsidiary overseas and get licensing fee back. GST issues apart.
Now, it depends whether you want the licensing fee or not.
So you can
It's up to
structure
you.
it. That's a question of structuring. But nothing stops you from owning your own trademark, or your entity owning a trademark, or you owning a trademark and licensing it either way, or you owning this trademark. And then a lot of times liability issues come in. These NCLT issues now are coming in where companies are going bankrupt, etc., etc. It's become a tough regulatory environment, or a fair regulatory environment, as some would say. So whether you want to own it in your personal name and then license it back, or you want to own it in the company's name and then license it in, that's a question. And investors will ask that. Investors will want the trademark to be in the name of the
Company that
company
they're
rather
investing
than being assigned. However, so there's a difference between an assignment and a license. License is something which you contract out. Assignment is something which is given by the assigned, which is in your name, inherently vested in your name. So it's a very interesting dynamics that people use, sir.
As an extension of this discussion, could you comment a bit on domain name squatting
Domain name squatting, right?
and the risks? It's an extension of the patent protection and trademarks.
So, whenever you think of a very popular name, you always find that the domain name is either taken or there is an option to bid for that domain name. That is a challenge that I think everyone faces. Even I face that challenge because I thought of names and I've gone and seen that that's not really available. I think the way around it is to kind of tweak your name to get some other domain name which is available if funds are a concern and you're not able to bid for that domain name. I don't know if there's some legal way around it that
I can administer trade names, which is the International Committee for Administration of Domain Names. So they have an arbitration system where you raise, if somebody is squatting your name or squatting a domain name that belongs to you, you can always raise a dispute, and you have to prove that it's squatting. It's with the intent and purpose of keeping you dispossessed from a legally goodwill trademark. So what will help your case is if you've got a product going, if you've got something going, and there is some kind of a passing off that person is doing and not making use of the trademark adequately. There have been multiple cases. McDonald's had an issue related to some of their domain names. How many of you have gotten mails from China saying somebody came and wanted to apply your trade name and wanted to apply? So I think all of us have gotten these kinds of things from different, and now with the domain name extensions, there are multiple extensions which are available. So .com and .in and .us and .cn might belong to you. However, somebody will apply the same, some squatter or somebody will apply the same make a same or similar website and you know take it from there. There was a very famous, not very famous, an infamous issue which had happened with a local, with a Chandigarh / Tri-City company, where I'll not name that company. However, what happened was instead of the I, small I, somebody, I mean, it is a name which is what, 6 letters, and in between is the I, right? In between there's an I. So instead of the I, they used L, and they squatted on that trademark, on the domain name. They made a similar website, opened an account in UK, and started asking they kind of hacked into their system, started asking all their customers to send money into the UK account. So classic case where so then we had to fight to get that parallel company domain name out of there. So go to the ICANN, say you've got to prove. So there can be there are multiple legal aspects which are multiple legal grounds on which you can oppose these kinds of domain names and take it from there.
But that's a lacuna in law that the trademark protection does not extend to domain names yet.
It helps that it extends it. It's a ground that you can take that there is violation. However, it doesn't on itself extend to trade names.
So could you talk a little bit more about process patents and how enforceable are they if you're really talking about a services industry? Your thoughts on that?
So so there's the law post 2005 allowed for product and process patents. Post pre 2005 there was only one class which was allowed. The thing about any intellectual properties is what is called the detectability. How detectable is your patent, right? How detectable are your claims? So depending upon that, that's when somebody is writing a claim. You've got to take your business into account, your law, the way it's granted, etc. into account, and then file your claim. So it is important that the claim that you're writing is detectable on an opponent's product or a process, right? If something happens within a factory, and you're not going to be ever going to get into how that process gets played out, then the product that comes out from that process might not inherently be as, it will be protected, but you might not be able to get it. However, if it's a product that you can get only by that process, then you are in safer territory. Right? It's a little technical.
It doesn't fall into the main patents or trademarks, but there are other agreements that when you start out, you would need.
Yeah, so that's the next part of what we were looking at. Now it's coming down to you've got this idea there, you've got basic protection, or you have a provisional application. Now you're getting your team, you're getting your first 5, 10, 15 employees. So what challenges would you face, and how do you want to take that from there? What happens?
So maybe we can start with your question and then we can discuss more on it.
Sure. One of the agreements which I thought was absolutely necessary was a co-founders agreement. Second, that was an understanding between the co-founders, and then we got it formalized.
Right.
I'm sure there are better ways of doing it.
Right. So there's a shareholders agreement.
Yeah, depending on what kind of structure you are doing. If you're doing a private limited company, then you have a shareholders agreement.
Yeah.
So we're doing an LLP, so there's a
Yeah, so
partnership agreement which is separate from the co-founders agreement. Do you think that's a good idea?
Yes and no. It will depend upon what kind of product, whether the company or LLP that you're forming is meant for that. So usually the LLP, the memorandum that you get out there could be a very small one, very traditional standard, and you could make an annexure which would have your terms or आपस के जो आपके agreements हैं in place.